Good afternoon, everyone, and welcome to Meltzer Hellrung's June webinar, Creating a Successful Plan for Site Visits. We'll go ahead and get started here in a few moments. Okay, I think we're going to go ahead and get started. It's about 3 after. Thank you, everyone, for joining today for Meltzer Hellrung's June webinar, Work Site Enforcement, Creating a Plan for Success. A couple brief notes here. We'll be covering creating a plan for worksite success today, worksite visit success, what types of work sites you can expect, and common questions to be asked, as well as I-9 compliance as we move from an ICE exception here over the next few months. We have 1 hour set aside today for the webinar, so we should have plenty of time. Today's webinar is for informational purposes only and should not be considered legal advice. If you have any questions specifically about what we're presenting or any other questions related to the webinar today, we encourage you to reach out to Matt or myself directly, and we'll be providing our email information and contact at the end of the webinar today. If you have any questions during the webinar, feel free to type them into the Q&A function. We will try to answer them in real time, and if too specific, we'll retain them and answer after via email. And finally, everyone that registered for today's webinar will receive a copy of the deck that we're using, as well as the recording that's currently underway. So let's go ahead and get started. A little introduction about Meltzer Hellrung. We were founded in 2014. We leverage technology, a service-oriented mindset, and a compassionate approach to assist high-growth corporations in scaling their immigration programs, increasing their access to talent around the world, and expanding their operations in a new market overseas. Our book of business currently consists of about 200 corporate clients. We handle, roughly 3,000 matters a year. Our book of clients primarily looks like high growth venture-backed unicorns in ed tech, fintech, SaaS, logistics. We also have Fortune 500 companies and actually global 200 companies in insurance, transportation, and manufacturing. We have been recognized in 2020 and 2021 as Inc. 5000's fastest growing US companies. And last year, we released a proprietary immigration management platform to facilitate and improve the experience of delivering our legal services to our corporate clients called Voyager. Voyager is an immigration management software platform that's designed to provide a seamless immigration experience for employers and employees. The Voyager platform was created for our clients and is used by our exceptionally trained staff of attorneys, paralegals, and legal assistants to fulfill our mission of improving the immigration experience for companies, employees, and their families. Specifically, Voyager drives efficiency, transparency, and information accessibility throughout the immigration process. So we structured it here, and I think you'll see a short screen grab, a couple of the more specific value propositions of Voyager as a platform. We have transparency throughout all immigration processes. Both you and the employee and the company representative can log into your platform, your section of the platform, your dashboard, and see your case, see exactly where it is in process, expected filing timelines, task completion dates. The workflows that we've designed in Voyager are super efficient. There's visa or matter specific, and they incorporate the best use of everyone's time from an employee standpoint as well as an employer. Voyager offers lifetime information and data storage, essentially a one source of truth for your company's immigration program. That's coupled with an intuitive user experience for employers and employees. And then finally, we have a comprehensive knowledge center that has blogs of most recent topics, collateral covering dozens of different types of visa processes and compliance issues with managing immigration programs, and links to government websites for good data, as well as things like the M274, which we'll talk about later. So feel free to join us or take a look at Voyager at meltzerhellrung.com. Here is a screenshot of a company representative logging in to their dashboard to manage their immigration programs. You can see on the left-hand side here, we have a very Google-oriented navigation task pane, as well as seeing open cases that are currently undergoing for the company as a company representative, the tasks that are specifically assigned to you as a company representative to complete. So we, Meltzer Hellrung, can move your process forward for your employee, and then process requests, which we'll talk about a little bit later at the end, but those pertain to review of candidates that you wish to hire, which we also provide as part of our service. Today's presenters, myself, as you've been hearing me speak here for the last 5 minutes or so, my name is Matthew Hellrung. I am a co-founder and managing partner of Meltzer Hellrung. My specialty generally corresponds to scaling corporate immigration programs for our high growth clients, our Fortune 500 and Global 200 clients, digging down into immigration policy and process with organizations that are looking to scale to create more compliant, more efficient, and a better experience for employers and employees. And then in addition to that, or capped with that, is also stakeholder training, which I do often for our largest clients, which is training your folks on what your immigration program is, how these new processes will work, and why it's important to maintain consistency for compliance purposes. With me today is my business partner and law partner, Matthew. You want to introduce yourself?
Hi, Matt. Thanks so much. My name is Matt Meltzer. I'm one of the other co-founders and partners here. In terms of my clients, I often work with companies entering the U.S. market for first time, entrepreneurs and other high net worth individuals looking to expand and grow in the U.S.
Great, thanks, Matt. We're going to launch our first poll here real quick, just to see who's with us today. I'd like to try to get a sense of the types of folks that are in the webinar, so we can direct our commentary and our narrative here to everyone get the most value. Just a couple more seconds here. So we're going to end that poll, display it for everyone. It's like the overwhelming majority of folks here are from human resources people off today. That's great. We have some folks from general counsel, sponsored employee, and some owner operators. It's a great group. We at Meltzer Hellrung deal with human resources people op and general counsel, as well as owner operators specifically all the time. So we should have a really informed discussion today. So let's move on to our agenda this evening, or this afternoon, and what we'll be covering. So we're first going to start off with site visits. What types of site visits you can expect. They come from different agencies at different times, corresponding to different things that you're doing in your immigration program or your I-9 compliance program. How to respond to these site visits, common questions that you can expect during various site visits by the various agencies, and then we'll finally end with best practices, including who should be included in a site visit plan. What is the response time? Do you include counsel? When do you include counsel? We'll roll through all of those things. After that, we're going to cover I-9 compliance. It's kind of part and parcel to worksite visits here, as it is potentially a type of worksite visit. There's also some I-9 things that are happening in the next 30 days. So we'll start with the end of the exception of the physical inspection requirements due to COVID, which is ending after almost a 3-year period. The future of what virtual renewal looks like. I think for a lot of our clients, there's pain points in reviewing documents in person for remote employees, best practices for the type of I-9 compliance setup that you're dealing with, and then how to deal with training for folks that are involved in that process. So from here, I'm going to actually initiate really quickly here our second poll, which is going to be, does your company currently have a formalized site visit plan? Another second here. All right, so it looks like about 15% or so of folks in the webinar today have some type of formalized site visit program. That's great. Hopefully you'll be able to pick up a few pointers how to modify that program appropriately with the current compliance scheme, and then about 86% of folks here are looking to create one, it looks like. So excellent. We'll go ahead and move on.
Thanks, Matt. So today we're going to talk about site visits of all kinds. Want to know that there's a lot of different kind of site visits. Today we're going to be focusing mostly on the first kind that's listed here, which is site visits from USCIS, and specifically FDNS, which is their Fraud Detection National Security Directorate, and that's the sub-agency within USCIS that handles site visits. The Department of State also has the ability to do site visits for things like TN visas, E2 visas, L1 blanket petitions that might have been done at the consulate where they did the adjudication of the immigration benefit. For the purposes of this presentation, there's really nothing you need to think about differently between USCIS and Department of State and what you're should be prepared for or how to react. They're going to behave very similarly. So although they are two separate agencies, I think in terms of what you take away from this, we're going to treat them as one. Occasionally, USCIS will also do work on behalf of the Department of State to do some investigations that if the Department of State has something that they want to understand when they're adjudicating a visa. 3 other agencies can do site visits. ICE handles I-9 compliance. So we'll be talking a little bit more about I-9 compliance later on. It's not so much a site visit as an audit if you're getting ICE visiting you. So we will talk about what to do in the case that you really get an audit request. Second is the Department of Labor. They can do validation on perms, really wage and hour. Typically, if you're getting a Department of Labor investigation, it's a question about whether or not you've paid people the appropriate amount of money, typically in an H-1B, E3, or green card program. And the last is the Department of Justice. And we're really going to do very little here. The Department of Justice is investigating you. In all likelihood, you have a lot of issues. So we're going to just, that's that's not just someone looking to check in on things. That's usually a sign that you're probably under a criminal investigation. That's a whole different ball of wax. So we'll know that it is possible, but we're not going to really touch that one today. All right. So site visits, how should you respond? First thing, if you get a site visit, call your attorney. If you get a site visit, make sure your counsel is aware that it's going on. Call them. If you are your attorney, call us. we're not going to be able to stop a visit. We're not going to be able to intervene, but it's really good for us to know we can make sure that other things in our schedule are put away, that we are available. If you have questions about what's going on, you can call us. If you have, if you're unsure how to answer certain things, you can have the officer talk to us. If you are getting an inquiry that's not in person, but by email, definitely share it with us before responding. These things can have long tails in terms of what the impact on both individual employees are and the company is. So we really strongly encourage you to reach out to us. If we are your counsel, if you have other counsel, reach out to them before you respond to anything. So I'm gonna skip ahead for a second. So I want to talk about what happens in a site visit and what you should be prepared for. Typically with a site visit, if one is to occur, you don't get any advance notice. Typically an officer is going to walk into your office and announce their presence then, and you're going to drop everything for when that occurs. You don't typically get the courtesy of, expectation of a visit. So the first thing is, who on earth at your office is going to handle this? For those of you who work at larger companies with a receptionist, you probably have something in place about what happens for an unannounced guest. If you work in a smaller office where you don't have a receptionist, make sure you know what happens when someone answers the door and who is going to do that and who gets notified if that person at the door is a government officer. You should by no means never say, turn around, don't come in, but there should be a process about what you're going to do when that happens. And so question is like, who is going to be the person who handles that conversation? Where is that person going to go? Are there any things you're going to say that are on limits or off limits? Our recommendation is generally to, first make sure the person identifies themselves, shows a badge or other representation that they are actually from the government. There are scams and schemes and frauds that do exist here. Call your attorney, get the contact information from the person, and then also make sure that you're trying to create one designated zone this person is in. You don't want a government officer just randomly walking around your office. Recommend if you have a conference room or a desk, get that person situated there, ask what kind of things a person is going to need, and try to bring the things to the officer rather than letting the officer just do as he or she wishes. The most important things to know are like, don't answer any question you don't know the answer to. Always be prepared to answer questions you do know. Ask for time, ask to be able to consult your information. They might ask, as you're going to see when we go back and talk about questions, a lot of the information they ask will be very, very, very particular. And you don't want to just like guesstimate. You want to give an exact answer to the best of your ability. So please make sure that you're not just riffing off the cuff, that you are being prepared with how to answer. And it's always acceptable to ask for time, the ability to review things. No individual at any company is going to know all the answers off the top of their head.
Matt, with my clients, I always highly recommend that they try to get any questions that are answered by the visiting officer in writing. So as to make sure they're very specific, so that we know what we're dealing with, that can be passed on to counsel. Also, if you don't understand something or don't know the answer, getting it in writing is really key, because we're going to have to follow up afterwards.
Absolutely. And it's acceptable when you're talking to the officer to ask, can we record this conversation? It's acceptable to have, say, I want someone in the room taking notes. Whatever the officer does with the information is going to potentially come back, and it's not really an easy way to contest it if it shows up in a request for evidence or a notice of intent to deny or other things in the future. So having a contemporaneous record saying this was not, this is what was said, this was not what was said, can be really helpful. So an officer may not allow you to record a conversation. If that's not the case, definitely look for contemporaneous notes. If they will allow for recording, I would encourage you to do so.
And I would say the officers can be very sneaky. They can say, oh, this is not a big deal. I'm just looking for some basic information. You guys should already have this. Why don't you have it? They may put pressure on you. It's really important to, stand steadfast there and ask for things in writing, make sure that you're only answering things that don't allow the officer to sort of pressure you into providing bad information.
Yeah. So let's talk about common questions here. I know there's a lot of information on this slide. We sort of just threw everything on here, but at the end of the day, there's going to be two sort of buckets of information. You're going to have information that is about the company that only someone at the company can answer. And then you're going to have information about the employee, which both could be answered by the employee or by the employer. And sometimes an officer may ask questions of the individual's employment to both a company representative and the actual employee to see if the answers are consistent. Like when you describe a job description for a person who works at the company, is it the same thing that the employee who works there is describing as their job duties? And if there's significant discrepancies, that can cause an issue. So things you should be able to prepare to answer about the company are, how many employees work for the company? What's the number of H-1B employees at the company? Who's working on site versus off site? What kind of supervision does the person receive? Those are all kinds of general questions. Like, again, the number of employees, the larger your company, the less relevant is whether you're exact to the number. There's not going to be a significant difference whether you have 1,500 or 1,600 employees. If you're a company with 25 employees, it is different if you have 20 or 27. So, the range in which you can be inaccurate is always going to be based on the size of the company. In terms of the number of H-1B employees, generally they're looking to understand, like, is your company considered H-1B dependent, which is a percentage issue? If you're nowhere near that percentage, which is generally 15% of your employees, it's honestly irrelevant if you're off by one or two petitions that you've sponsored. If you're on that cusp of being H-1B dependent, where you have that 15% number, if you're not quite sure, talk to your attorney, talk to us about what that means. You want to make sure you're really accurate about how many active H-1B employees you have before answering that question. Then there's going to be all kinds of normal questions, like what is the person making as a salary? What are the working hours? What are the job duties? Who supervises this employee? How does the supervision occur? Generally, in terms of supervision, if you are a company that sells your own product, this is just a non-issue. If you are a company where individuals are placed at third-party work sites, that becomes a much bigger issue. So, the relative importance of any of these questions is going to change on the circumstances related to the company. And again, I think this warrants a conversation with your attorney. What questions should be most you prepared to answer at all times? Because certain kinds of questions, you want to give them an answer, but it's not going to make or break anything. And certain questions are going to be really, really important. One thing I do want to note about these questions is that the USCIS is going to be putting forth a regulation. We have not seen it yet, but they're expecting to put together a regulation at the end of this year that is going to solidify what the FDNS site visit process is to look like. And so keep alert at when that comes out, when that proposed regulation comes out. We will certainly be looking at it closely to see what exactly they're going to try to solidify in terms of how these processes work. The other thing I just want to note about site visits before we go on to what happens if you're getting the inquiries coming in by email is that the USCIS tends to have two categories of site visits. For individuals on H-1B and L-1, there's some degree of randomness that is supposed to be designed and built in. They could visit any employee. Clearly, employers who have certain kinds of records of like non-compliance or have employers, especially who do third-party work sites, might be at a higher likelihood for getting a site visit. But any H-1B or L-1 employer can get a site visit. For individuals on other visas, whether that's E-2s or TNs or O-1s, anything else that comes through USCIS, generally they don't do randomized site visits. Site visits on those particular visa types only occur if they are getting some sort of trigger, which is some sort of reporting from something is set off based on an application. They get some sort of tip from individuals elsewhere or another government agency. So if you get someone coming for a site visit that was on something that is not an H-1B or an L-1, that should set off alarm bells at your company as well, because that means they have come based on some sort of information or tip. So let's go over what happens with emails. A lot of times FP&S officers are not just visiting offices. They will send an inquiry by email, and they will typically, want a response to that email generally within a business day. I strongly recommend having your counsel, as us, we would be, please email us, contacting them before you respond to any of this, because anything that's in writing, you want to be really careful about. And when you do respond, I strongly encourage you to keep your counsel copied on those, on that communication as well. Keeps officers honest. And honestly, I think officers are a little bit better behaved when they know that an attorney is present. One real-time question is, do E3s fall in this HL category? So E3s would again be something that is not a randomized audit. That is something that will occur only if there's generally a trigger. The most important thing with any email is making sure that you're going to be consistent with what is happening in the petition. And if the facts on the ground are inconsistent with what is in a petition, then it's important to figure out how you want to respond to that and saying, what your course of action is going to be. Certainly, we've had clients in that situation, and we typically will advise, okay, you are not compliant today. You should not try to hide your non-compliance. You should say, this email is making us aware of our non-compliance, and therefore we are going to respond honestly, and here are the steps we are going to take immediately to resolve that non-compliance. Never, ever, ever lie. That's much worse. Here's my favorite area of site visits. If the person is working from home, that means a site visit can occur at an employee's home office. So what do you do in that situation? You should definitely make sure your employee knows who to call, because that person still should respond to the officer, but they should be aware of what the company's process is. What can they answer? What can they not answer? What do they have to answer with a company representative on the phone, or Zoom or other kind of chat function? Or what can they proceed to do independently? My recommendation is that they should only be answering questions if there is a company representative who can teleconference in, and that the employee should say, I'm happy to talk to you, officer. Clearly, this is about my employment. I'm under strict instruction from my company not to answer any questions about the company representative. Can we make can I call my HR so that we can create a conference call immediately so that we can talk? If the officer says no, I would honestly have the employee say, unfortunately, it's contrary to my employment to answer your further questions. I need to have that possible, please call here's my supervisor. I'm required to ask you to call that person immediately. Certain basic questions, like what is your job title? Do you live here? Things like that. You shouldn't worry about with any degree of concern.
Matt, interesting question here for Q&A.
Yeah.
Do employees have a legal obligation to admit an officer into their home?
They don't. I mean, you're still a Fourth Amendment question here. Those Fourth and Fifth Amendment questions of basic constitutional jurisprudence of, you don't have, if there's no warrant, you do not need to let an officer into your house. I think it's each company and employee can approach that individually. It's certainly warranted to say you can't come into my house. It creates a little bit of awkwardness if you're going to say I'm going to talk to you only in the hallway. Clearly, if you are an individual, you have employees who you think the culture is that they might have things like marijuana paraphernalia or things in their house. You really don't want a federal government officer entering the premises. So I think that's a question of what you want to do as a company. and how you want to advise employees in what to do. But an employee does not inherently need to allow the officer into the house. But that said, if you don't allow the officer in, it can have repercussions down the line where an employee, if the questions aren't answered, the government officer can use that as suspicion to say, like, we don't believe that this is a good faith visa application, and that's a whole new set of headaches. So it's a real question. There's not an absolutely good answer on that.
And one last
feel the same way.
Yeah, I absolutely do. I would keep the officer outside, just be as pleasant as possible. I mean, it's just like having someone enter your office, offer them coffee, water, whatever. I would, if you have a policy that the employee needs to call the employer, have the officer stand outside, have the employee go inside, call the employer, get additional instructions on what needs to happen there. But I completely agree with Matt that you shouldn't be allowing federal officers into your house, or you're not required to. There's one additional thing here, one additional point here that was asked, and the question here is, should we anticipate these are quote unquote gotcha type visits? Are they looking to trip us up? As Matt mentioned earlier, I think there are two general types of visits. One are just general compliance visits that are randomized. And then there are other types of visits, or perhaps succession of visits, that would indicate some type of enforcement priority, or perhaps bad actor or reputation within the government about your company. So it's difficult to tell. I would treat any site visit seriously and as something that is just part of regular compliance if there isn't an overarching theme to the visit itself, or a succession of visits that you've received.
Yeah. And in terms of those gotchas, I think some of it is really just dependent on the officer and the culture. The different officers, we never really know the incentives that, like, do they have a quota of finding negative things or anything like that? And some officers, I think, are really honorable and are just trying their best to just execute their functions, their job, and some are looking for opportunities to have a negative experience. All right. One more question that's live right now. Is it okay to ask the officer to come back when someone else is home if the person is alone and uncomfortable? You can certainly ask. There's no harm in asking. It's certainly okay to say, like, I would prefer to have someone else present during this. Is it possible to arrange a time to come back? Like, someone will be here at the following time or tomorrow. The officer is under no obligation to say yes. They may as a courtesy.
Matt, that's just sort of triggered, I think, a piece where we haven't touched on yet. It's always appropriate to ask an officer for valid identification, federal government identification. You should be able to show that to you to prove that they are who they say they are. There is a lot of fraud in immigration in general that's committed by third parties preying on foreign national employees or foreign nationals in general, acting as government officers. And an employee, then finally here, can an employer ask for the revisit? Yeah, an employer could, again, potentially ask for the officer to come back or leave. In this case, I would say leave a list of questions that can be responded to via email. But again, there's a balance here between polite compliance that facilitates a more pleasant transaction or interaction with the officer, and I guess the other side of it would be kind of stonewalling, and that may make the enforcement action more serious, even if you're not necessarily non-compliant as a result of how you treat this officer. I always, as an attorney advising my clients, this is just a person doing a job just like the rest of us. Let's facilitate and make their job as easy as possible without exposing the company to any additional liability or compliance issues. And I think it's just good to have a good working relationship with these folks. If you're a large company and you have a lot of foreign nationals in a particular area, I've experienced this with some of our large clients. They know the company well, they know the points of contact well. They'll come around every maybe once a year, every 2 years, as the individual doesn't change. And it helps to have an ongoing pleasant relationship with this person.
Yeah, I completely agree. And really large clients, they might have multiple sites visits a year, just as course of action. And so, yeah, the more you have, if you do have a rapport with an officer, it's going to give you probably some leeway. If you 90% of the time say, we're happy to talk to you right now, and there's a reason, 1 out of 10 that you don't, like, the officers, just as with any other relationship, more likely to give you that respect.
There's like one more. I don't think we got that. Okay. Lots of really good questions on that section. So we're going to move on. Feel free to, if you have any other existing questions, email us after. But we're going to kind of switch gears here and talk about I-9 compliance. As there's an exception that was granted during COVID that is going to be expiring next month. Generally, I-9 compliance visits will start to increase as a result of ICE officers now doing more in-person visits as a result of the waning pandemic. So in March 2020, there was a Immigration Customs Enforcement implemented an exception to the in-person physical inspection requirements. Before I get to the rest of this, the rule there is that all documents presented by an individual during the I-9 process must be physically, that means in person, inspected by either a representative of the company or the company represented themselves. This is all a requirement under any I-9 circumstances, even if the employee is working remotely for your organization. As a result of obviously the pandemic in March 2020 and everything shutting down, ICE allowed an exception to this in-person inspection rule and said that I-9s could be completed remotely via email, or GChat or Zoom, and the documents themselves could be inspected remotely as a result, typically provided as copies via email. But this only applies, and this is often a misconception, it only applies where your company's office was completely closed. If you had someone that was going in or a rotating like ghost staff during the pandemic, and you kept your office open, technically this exception does not apply to you. And if you were using this exception to get around the in-person inspection requirement, we'll get to how to comply later on, but you may be out of compliance right now as a result. Long story short here, this exception ends July 31st, 2023, and then is followed by a 30-day grace period that allows companies to essentially re-inspect all the I-9 documents for individuals that were hired during that grace period in person so that you are compliant. I strongly recommend if you haven't started doing so, you do so now. Getting documents around from employees, getting the same documents that were provided previously, getting those documents shipped or deputizing someone or using a service to inspect those documents can take some time to set up. And you have roughly about 30 days, so we get started immediately if you haven't done so.
And just one thing to note about this too is the luxuries people got used to during the pandemic. The ICE is expected to propose a regulation later this year that will give them authority to create a trial program that would allow for a remote inspection of documents. We don't know not a lot about that yet, both about the regulation and exactly what that trial program may look like. But ICE is wising up to the 2020s and that many employees work remotely and the whole in-person inspection of documents is not feasible or realistic for the modern era.
There's a question here, and I'll answer it right now because we're on this topic. Is well, how do we do these inspections if we're not in the same location as our employee? The employee potentially is in different states. You have to have, so there's a couple different ways to do this, and just shortly, I would say you either have to have the employee come to you with the documents, go to the employee with the documents, or use some third party to inspect the documents on the company's behalf. We can get into what type of third party we'll use later on here as a compliance section, but it could be like you could deputize the employee's spouse to act on behalf as an agent of the company to inspect the documents. And that's one solution. And as Matt mentioned here just a second ago, there is a final rule by the Department of Homeland Security to provide alternatives to physical document inspection for the I-9 process. It's currently targeted for August, the final publication of the rule here. We are monitoring that very closely, and we'll have a blog article up as well as some additional advice when the final rule is ultimately submitted to register and will be implemented within 30 days. Next slide, please. So let's talk about creating an action plan for I-9s in general. So when you're reviewing I-9s here as a result of this exception ending, review all the I-9s that were of folks that were hired between March 2020 and July 31st, 2023, and what documents were provided as a result of that non-in-person inspection that will now have to be reviewed physically. For on the front end, what we did when this exception went into place and found that some of our clients were using it, can't do this necessarily now, but look via dates for completion. If you have, or most of our clients, we advise put these I-9s in a separate place, in a separate folder, separate stack, because we know that we're going to have to come back and implement this physical inspection requirement when the exception expires. Here, decide whether you need to perform the physical inspection of the documents at the work site, or as we mentioned before, you can use an alternative third party. Here we can get into third party alternatives. There are some HR service management services that will perform this type of in-person I-9 document inspection. You can contract with them to have their representatives sent out to your employees' homes. There are large sort of credit agencies that offer this type of service as well. And then more recently, we're seeing payroll providers like kind of tech-oriented or just sort of old school payroll providers offer this service as a result of everyone working remotely and employers in a position where they can't always be physically inspecting documents of employees that they're hiring remotely. Again, this only applies for folks that would be physically located in the United States, with the exception that if they are a U.S. employee or U.S. citizen or permanent resident, that may apply. You may have to fill out an I-9 there as well. In addition to that, here, I think we have a question.
And I apologize if I missed it. We talked about whether talking about like the roommate option of having your.
Oh yeah, forgive me. Yeah, so and thank you, Matthew. The second option here, instead of hiring a company, would be to deputize an individual that lives like in the person's house via an agency agreement with that individual, specifically with the scope of reviewing and the documents that are required to be completed in the I-9 process. If you do that, or even if you hire a company to do it, if you're not using sort of the roommate or spouse exception here, the deputization exception, you should still have somebody internally that reviews the documents via email or copy, as well as the actual I-9 via email or copy or electronically, to make sure that the person that was responsible for completing the I-9 and reviewing the documents did so correctly. You, as the employer, at the end of the day, when an ICE shows up as an audit, are always responsible for any mistakes that you've made, even if those mistakes were delegated to a third party. It's really important as part of your process to have it centralized. We'll talk about this later, and then make sure that regardless of what method you're using for remote review of these in-person documents, that you have a check internally that is ideally a W-2 employee that's responsible for making sure that compliance component is satisfied. Here we go. And then finally here, to train employees on the conduct of physical document inspection and updating I-9 forms. It's really important, whoever owns the function of completing the I-9s here, whether it's this exception or just generally, that they have training on how to complete I-9s. It is a simple form, but it's very easy to screw up. Things like using the wrong addition, like inputting data in the wrong places, asking employee for documents. These are all things that seem natural as part of that process, but can actually be violations. We have a few questions here. We're kind of rolling in. I want to make sure that I get to one. I'll tackle. Does a notary count? Yeah, a notary can inspect the documents in person, but again, a notary is not trained to complete the I-9 form for the employer, as well as actually inspecting the documents. So like you're delegating to a third person who is not trained on how to review I-9 documents, nor and is acting on behalf of the company in that particular instance. So again, I would have an internal check if you're using any third party, including a notary, to make sure the I-9s are completed properly. So I want to differentiate here between completing I-9 and doing E-Verify. So every employer, whether you complete an I-9 electronically or via paper form, is required to have an I-9 for every employee that's a W-2 on payroll. E-Verify isn't one additional component or additional program that you can complete or you can participate in that then takes the information that's input into the I-9 and runs it through several government databases to check to see if they're actually accurate. What they're looking for here is potentially mismatching in names and social security numbers, other things that may be problems, or like passport numbers, other things that may be off in a government's database that would then come up as what's known as a tentative non-confirmation. The E-Verify system will spit back out to you, the company representative, hey, there's something wrong with this employee's records or the information provided or how it was input, which can sometimes be the case. of employers just simply inputting data wrong. There's something wrong here. There's a mismatch of that information, and then that kicks off a tentative non-confirmation process where the employee has several days to respond and then try to fix that information. And there's a bunch of different procedures after that we won't get into today, but just want to make sure that people understand the difference between completing an I-9 and then thereafter participating in the E-Verify process. Okay, next slide, Matt, please. So now we're going to talk about completion and centralization and storage of I-9s. We talked a little bit about how to complete them. If you haven't remote employees, who should complete them? And that's, I think, one of the biggest issues that most employers are facing right now with the remote workforce. Generally recommend all I-9 should be kept in a centralized location at each company office. If you're doing in-person verification, you have maybe a dozen different company offices around the country. They should all be kept in person if you're using paper. You can also, obviously, there's a lot of digital I-9 completion technologies that can be used for this. We would say generally it's great to have, even if you have a few offices, to try to centralize all I-9 documents in one electronic storage file or one physical storage file within one company office as much as possible. When you have different individuals completing the I-9 process at different offices, the variability of individuals' knowledge of completing those I-9s on the company's behalf with employees it varies and leads to a lot of inconsistencies. And generally, when a compliance action or an audit is issued by ICE, we see those inconsistencies and they turn into compliance issues and fines. So centralization of the documents themselves, and also centralization within a small group of people or one person consistently that completes I-9s for everyone in the company. We generally and strongly recommend there's a book that the USCIS publishes every year that ICE contributes to as well. It's called the M274. It gives instructions on exactly how to complete I-9s to employers and employees. Certainly, you can always ask us at Meltzer Hellrung for your counsel. We specialize in this as well. But I'll be honest, what we do oftentimes is reference the M274 to make sure that the advice that we're giving consistently to clients is accurate. And we provide that book and that information to clients directly too, if you wish to educate yourself on the process. Most importantly, with completing I-9s, never request specific documentation from a new employee to complete an I-9. We recommend strongly you just provide a list of acceptable A, B, and C documents to the employee. Allow the employee to provide whatever they feel is sufficient. If the employee does not provide something that is sufficient, then you can give the list back to the employee and then ask them again to provide something that is sufficient. Explain to the employee why the document they originally provided does not meet the requirements of list A, B, and or C. But key there, never ask for documents specifically. And from the employer side here, I think it's important to note that make sure that you as an employer are using the correct version of the I-9. There are editions that are updated every few years, right? Sometimes multiple times in 1 year. So make sure you're using the most up-to-date edition, as some of the data fields change and some of the directions change. And that itself can be considered a violation if you're using the wrong edition of I-9. As I mentioned, the form is really simple, but it's really easy to screw up. Next slide, please. Best practices here for retention. So once you've completed the I-9 process and now you're storing it, how long should you retain it for? What types of audits should you complete as part of this process? We recommend generally that I-9s for mid to large size companies, even small, which may not have a lot, should be completed on a biannual or annual basis. It's important to understand how many I-9s you have, how they're being stored, where they're at. And then we often recommend doing, like, you don't have to audit the entire storage of I-9s every single time, but maybe do a spot audit for the I-9s that were completed within the last year. You can have counsel like us do this to see if there are any inconsistencies or compliance issues that are being created with the implementation of a new process, moving from paper to electronic I-9s. The changeover in individuals that are completing the I-9s on behalf of the company. Those are all things that can lead to compliance issues, and why you want to do at least a spot audit annually or biannually to understand what your liability may be if ICE shows up and audits you. Purging is also a great way to limit your liability. You are allowed to purge or get rid of I-9s once employees are terminated. There is a specific rule here, which I'll get into. But in general, we've had issues in the past where employers want to provide all their I-9s, and we have to quickly purge a bunch of them to make sure that if they're not required to be handed in, we're going to purge them in an audit action to make sure we don't give them to the government. If we give unpurged or purgeable I-9s to the government and there are mistakes made in those, you can be fined for those additional I-9s, even though technically they could have been purged and that liability could have been avoided altogether. The rule here with purging I-9s is fairly simple. An I-9 can be purged for an employee 1 year after they have left, or 1 year from the date of termination, excuse me, or 3 years from the date of hire, whichever is greater.
And just I want to emphasize, Matt, back to the inspection piece. Even when ICE comes looking to inspect I-9s, they give you 3 days to hand them over. And those 3 days are by statute. So there's no grace period, there's no kindness. You just have 3 days. And so for most organizations, 3 days is what you time. You just need to like get things organized and hand it over. Getting any further auditing or removal of things is going to be nearly impossible for most organizations. So this sort of like good housekeeping of purging and auditing is really designed to allow you to breathe easier when an audit comes. And I think it's also just important to note that, ICE audits themselves, Matt, like, would you agree with this? Like, different companies need to assess their likelihood of an audit. ICE is first looking for companies that have unlawful workers, not just I-9 violations. So they tend to look at industries with low skilled work. If you are in landscaping or manufacturing, agriculture, those are industries that tend to get audited first. But you can also get audited just based, again, on a tip or some other randomness. So even though tech companies don't tend to have a lot of unauthorized workers, in other white collar businesses, they can still get audited. We have seen in the past where clients of ours have been functionally doxxed. I don't know if it's like something someone sees on Reddit or what happens, but a company, a disgruntled former employee, basically takes it out on their employer by reporting them to ICE as potentially having unauthorized workers, and all of a sudden you're going to be in for an audit.
Yeah, and that's the biggest, and for, I would say, tech companies, a lot of our clients that we do work visas for, that is the number one reason why they get audited, is a disgruntled employee makes a complaint that sets off an ICE audit, unfortunately, that costs the business money and stress and time. Quickly here, I think we have a few minutes left. I'll get to those 3 questions. I don't want to move on. I'm going to make sure we cover everything. Here we have, is there an issue with doing paper I-9s for those that are in the same office or state, but doing electronic I-9s for those employees that are remote or out of state? Is that okay or considered an inconsistency? I think inherently it is an inconsistency. I would say if you're going to do electronic I-9s, I would do them for everyone, move it all over to electronic. We find with auditing and helping clients implement electronic I-9 processes, the technology is fairly good. Most of them are compliant, and it gets around some of the misinformation or wrong data field completion that can cause fines during an ICE audit. I would say one thing here is, if you're using electronic I-9 for the review of documents, that is not sufficient. You have to have someone still personally review documents in person. The individual cannot send copies to you that you then review at your central office. You have to have someone physically in the presence of that employee, provide that person documents and then inspect them. Do we need to see original documents of an employee's age? Sorry,
just I would add to that, Matt. Well, there's no technical legal issue if you use 2 different methods. There's not a legal problem of using electronic I-9s and then paper I-9s for different employees. We would just encourage you to use one for consistency, but it's not like as long as you have all the I-9s recorded and saved, it's not going to inherently cause a fine.
Yeah, absolutely. Do we need to see original documents of an employee whose H-1B extension was filed with us? Yes. Matt, what do you think there? My answer would probably be yes. A copy of the original, or it's kind of a sticky gray area question. I think reviewing the original approval notes would be ideal. Oftentimes employees don't have them, though. They are providing copies, and that should be sufficient as long as you're notating the exact case number. There's a little notation that's required by the MT-74 in that situation.
And I would just add that the I-797 alone is not sufficient for your I-9, so you would still need probably to see a passport.
Correct. Here we go. Can we purge re-inspected paper I-9s after scanning and storing them in a centralized storage space? Yes. This is a question we get a lot currently from our clients, which is when they're transitioning from paper to electronic. Do we keep, the paper and electronic, just start, from this day forward doing everything electronic? What do we do? In most cases, we see employers will select to do an audit of their paper I-9s to understand their liability, looking backwards of what they have to store. And then oftentimes employers will scan all that stuff then into like Workday or some other type of system that you're using. You can do that. That's completely fine. And then thereafter, you could get rid of those original documents, the paper documents. But I would be careful here when you make the scans, make sure you scan front and back. There are notations sometimes on these I-9s that are really important in an ICE audit, and we don't want to miss a piece of information as a result of the fact that like the back of a document or the bottom of a document wasn't scanned properly. So in general, if you're concerned about that, I would say keep the paper, use the electronic going forward, and then eventually those paper I-9s that were for employees over the years will be purgeable, and it'll become a smaller and smaller and smaller batch of paper I-9s, and everything else will be electronic. To document the time of hire is expired, which document to check? I mean, this goes back to, I think, the list of acceptable documents. All documents generally have to be valid at the time of hire. If they're not, I would say that I would tell the employee that this document is expired and they need to provide a valid one. If it's a passport, they need to get a new passport because it's expired. There are specific instances where accepting expired documents may be acceptable when you're talking about extensions in the business immigration or visa process. But overall, if somebody's providing something that is expired, you can't use it, and they have to go and get an unexpired document as a result of providing them the list that they can choose from. And then here, lastly, so how do you kind of pull all this together when you're creating a compliance retention storage program? Do trainings with your folks. We offer this as a additional service at Meltzer Hellrung, but it's really important to kind of do a training with either outside counsel or internally about how your process will work, making sure all stakeholders involved are in that training, making sure everyone understands what the process is, why it's being done this way. So that individuals don't make mistakes that are completing these I-9s or storing these I-9s going forward. I think the biggest issue we see with companies is just generally people problems with completing the I-9s. And you can see that maybe somebody completed 100 or 300 I-9s completely incorrect, and then the next person did it correctly. We see those when we do the audits for clients and that personnel switch over. So when personnel turns over, if you don't have a current training or audit plan in place, create one, train everybody. And then every time personnel change over, make sure that part of that onboarding process with that new employee that will be touching this is a short training on I-9s with something that's been recorded or created by the company or with outside counsel.
And just to reiterate this, if you get audited, ICE can fine you for technical violations. It's not just a question of did you have unauthorized workers. Mispreparing the form or checking wrong boxes, having wrong documents can get you fined, and fines can go up to several $1,000s per violation. So it's a couple 100-person company. It is not unreasonable to see fines that are six-figure numbers just for mispreparing an I-9s. So it is serious. It's not going to get your company closed down, but it is going to get you, it's a bad day when you're in charge of I-9s and you get audited, and down the line, there's a six-figure fine coming in.
Absolutely. And just to note there as well, there can be multiple violations per I-9, which I think, forgive me, don't quote me here, but I believe the current substantive violation number is $2,100 per violation. There's multiple violations per I-9. That's why it's really important to complete these I-9s correctly, store them correctly, have outside counsel or internal audits, and make sure that if you're involved in a NICE action that you're giving them what they need. One point here just to touch, and I think we're going to skip the Voyager section here at the bottom and just go to our contact information, as this seems to be the most relevant topic today. But having counsel that has a good relationship with the ICE officers in the local ICE office, there can be considerable differences on an enforcement depending on the ICE office that you're dealing with. If you are audited, which again is not necessarily always the case, it's random, and there's a very low percentage of anybody getting audited. But dealing with the office in Seattle would maybe different than dealing with the office in like Arkansas. The officers' priorities are different. their manner of working may be different. The processing time when you hand in audit documents can be completely different. So it's important to have counsel that's knowledgeable about the ICE audit process, I-9s in general, and then has some experience in dealing with maybe the local office that you're currently dealing with, as again, these ICE offices have a large variety of processing times and sort of compliance or enforcement stances, depending on location. That will conclude our webinar this afternoon. We really appreciate everyone's time. Hopefully this was helpful. As a reminder, we'll be sending out a copy of the webinar recording as well as the deck to everyone that registered. And if you found anything interesting today, would like to see have an overview of our services or a demo of Voyager, here's our information. Please contact us. And if there are any legal questions that are outstanding from today's webinar that you'd like to have answered, feel free to reach out to us as well. We hope everyone has a lovely July 4th weekend, and thank you for your time.